when he was a student at Brookdale. So it's a particular honor to be able to work with him and to collaborate on wonderful programming in our institute. And so thank you so much. Today, we're going to talk about the ERA, the Equal Rights Amendment. And we're going to talk about, is it dead or will it be the 28th Amendment? And I am Jane Scimeca from the History Department here at Brookdale. And I want to, first of all, thank you for inviting me, Jonathan. It is really wonderful to have terrific colleagues like you and Tom Ciappa in the political science. And I really, really appreciate you inviting me. This originally was supposed to be a women's history commemoration for March, but if anybody who knows me knows that every day is women's history. I teach women's history here at Brookdale for over 25 years, and I teach world history as well, World History 1, which is History 105, and World History 2, which is History 106. And I want to invite you to consider my courses. I hope in the fall you will all enroll for courses at Brookdale. We love you. We want you to come back in the fall, and that you will consider taking my women's history class or my world civilization class in the fall. I would love to have you as students. So without further ado, let me begin to talk to you about the Equal Rights Amendment. So today we're going to have a few goals, right? We're going to talk about the history of the Equal Rights Amendment. We're also going to be talking about the history of women's legal status in the United States, because that's really key to understanding the need for the Equal Rights Amendment. You have to understand, where do women stand in the eyes of the law? We also are going to explore, do we need it? And is the ERA something that's important, or is it redundant? Is it even necessary? And we're going to look at the history of what happened with the ERA, and we're going to see, why did it fall out of the public eye? Is it dead? What happened to it? And we're also going to look at whether it will eventually become the 28th Amendment. And I will give you one or two of my predictions about what I think is going to happen with the Equal Rights Amendment. So these are our goals we're going to be talking about. And I was mentioning to Professor Moshberger before we began that this topic is just perfect for the History and Political Science Club, that it is the perfect intersection of women's history and political science. It really is really falls in that perfect sweet spot in terms of having a good story. So sit back and enjoy the discussion here today. So we're going to start off with the Constitution. So as I said, this is the sweet spot between politics and history. So what is the Constitution, right? The Constitution was written in 1787 and has been in use since 1789. It is the oldest, right, of the global constitutions. And it has become the charter of the United States government. It created the United States government, and it really is a very concise and clear statement of principles. So I always try to explain to students that we don't look at the Constitution as a formal law code. We have a federal law code, and we also have the Constitution. And the Constitution sets forth the principles of our government. It is not a detailed plan, but it guides all law and all judicial decision-making. So when we listen to the news, sometimes they'll talk about the Supreme Court had come to a decision on a case, and that is always guided by their interpretation of the United States Constitution. It has only been amended 27 times in US history. So that's not very many, especially considering that the first 10 amendments are the Bill of Rights, right? So really very infrequently does the Constitution receive any amendment or change? And that's something I think important to recognize as we look at the history of the Equal Rights Amendment. It also is important because it begins with the statement, "We the people," and that the Constitution is important because it establishes the fact that the people elect their representatives, that this is a government to serve the people, and that the Congress was created in the Constitution to oversee the other two branches of government. They call it the three-legged stool, right? The judicial branch, the executive branch, and the legislative branch. Well, the Congress, the legislative branch, was created to oversee the other two branches of the government. And it also has Article 5 powers. And the Article 5 powers that the Congress holds gives it the authority to approve amendments. So keep that in the back of your mind as we talk about this very complicated history of women in their legal standing, as well as how something becomes an amendment to the Constitution and who gets to say whether it is or it's not. All right, so here we go. A little background on the Constitution. So aren't women already in the Constitution? I mean, this becomes the big question. The Equal Rights Amendment is an amendment to the Constitution that would address women as being part of the Constitution. Well, I always emphasize this in my women's history class because it's very shocking to women today to recognize that women aren't included in the Constitution. And so when the Constitution was adopted, women are not mentioned in it. And this brings up some very important issues. As recently as a few years ago, Justice Antonin Scalia, who passed away in 2016, as you may remember, but Justice Antonin Scalia famously stated that women are not in the Constitution and they should use the legislature or the ballot box and do something about it. And when a member of the Supreme Court says that women are not in the Constitution, we should pay attention, right? Because this is the highest court in the land with incredible authority. And Justice Scalia said this, and it really perked up the ears of women in the country to hear someone say this out loud, that women are not included in the Constitution and that they should do something about it. So this is a recognition that the original intent of the Constitution, the original meaning of the Constitution, did not see women on equal legal standing. So when we talk about the history of the United States and the status of women in the eyes of the law, we have to go all the way back to the beginning of American history. And we have to remember that the colonies in North America were established by European countries. Western European countries settled much of North America. England, France, Spain, Holland, all had colonies in the 1500s and 1600s in North America. And they brought with them everything, right? They brought their people, they brought their laws, they brought their customs, they brought their way of life. And in the English colonies, they brought their law system. The legal system of England was called the English common law. And in the English common law, women were not viewed as legal individuals. And if a woman was married, she had a different status than if she was single. So a married woman was considered a femme couverte, which is a French term, right? A French word in the English law code. Femme means woman, right? Feminine, femme. And couverte is covered. So who covers her? A woman's legal existence is covered by her husband if she's married, right? So she is not a legal individual. She is part of a married couple, and he speaks for the both of them. The man is the head of the family and the head legally of that unit, the family. So the focus of the English common law was on governing family units, and the father was the focus of this legal understanding. So women were not legally individuals. Women were not allowed to inherit. So if father dies, money goes to son, not daughter. Women could not make a contract. She was not a legal individual. So even if you look at deeds, oftentimes if you look at old deeds from the time of the colonies, the deed to buy a piece of land would say John Smith and Uxor. And Uxor is Latin for wife, right? So her name isn't even on the deed. She's not a legal person. She's just John Smith's wife, right? John Smith and wife buy the land, okay? So she is not a legal individual. Women also were really like a junior partner in the family. Women did not even, were not entitled to custody of their children. They certainly could not vote. And in the case of legal cases and criminal cases, women could not serve on a jury, could not bring a lawsuit in court, and could not control their own wages. So if women earned wages, her husband was in charge of that money. She did not have control of her own money. So when we look at the English colonies in North America, women were looked at as covered by their husbands and not as legal individuals. So why is this significant? This is significant because when we go back to understanding the way women are viewed by the law, women were not viewed as legal individuals in the English common law system. And when the United States is established after the American Revolution, this is carried into US law. The English common law system became the basis for the United States Federal Law Code. So these customs and standing of women follows into United States history. So you may have seen these two women before. Elizabeth Cady Stanton is sitting and Susan B. Anthony is standing. And these two women represent some of the earliest women's rights advocates. And so by the middle of the 1800s, women's rights advocates like Susan B. Anthony and Elizabeth Cady Stanton began to work to reform the laws. And, you know, most famously, you know them as being leaders in the movement for women to get the right to vote. But they were also concerned with more than the right to vote. They were also concerned with femme covert status and ending femme covert status. In fact, they lobbied state legislatures. Now, these women didn't have the right to vote. All they could do was send petitions. Their only legal voice was to get signatures on petitions, deliver the petitions to the state legislatures, and hope that the men in the state legislatures would take notice of these petitions that asked for and demanded changes to femme covert status. They wanted to reform all those laws that women should be able to own property, that married women should be able to inherit, get divorced, have custody of their children, and they also demanded access to education, access to professions. And Elizabeth Cady Stanton very famously argued in the Declaration of Sentiments in 1848 that women, when they become married, are civically dead in the eyes of the law. They essentially no longer exist in the eyes of the law. And so they really point out and work for not just the vote, but for reform of women's legal status in the 1800s. So then we come up against this idea of originalism. And I'm sure in your political science classes, you talk about the Supreme Court and you talk about how the court makes decisions. Well, in the judicial education, and judges have different backgrounds, and some judges identify themselves as originalists. An originalist judge means that they rely on the original understanding of the Constitution in making their judicial decisions. So let's put some of these dots together now, connect A, B, and C. Women are legally not in the Constitution. Justice Scalia told us that. And the English common law system also viewed women as legally non-existent after they become married. So if these judges, and these are the three originalist judges on the Supreme Court, plus our latest Supreme Court Justice, Amy Coney Barrett, recently, all four of these current Supreme Court justices identify themselves as originalists, meaning that they make their judicial decisions based on the original understanding of the Constitution. The Constitution did not consider men and women equal in the eyes of the law originally. So, if these justices are originalists, then we really need something in the Constitution to fix this, to give women equal standing in the eyes of the law. And so these are the questions, right? So if you need an amendment, let's talk about one. So what is the Equal Rights Amendment? The Equal Rights Amendment is very simple. And as I said, the Constitution is written to be a very simple guidance, right? Simple guidance for principles of the country. So the Equal Rights Amendment is very plain. Section 1 says that equal rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2 says the Congress shall have power to enforce it. And 3, that the amendment shall take effect 2 years after its ratification. That's it. That's the whole thing. Pretty quick, pretty simple, right? Pretty direct. So the Equal Rights Amendment, is it needed, right? We know that it is not part of the Constitution yet. It is not yet part of the Constitution. However, surveys reveal that 94% of Americans support having an Equal Rights Amendment in the Constitution today. So it is overwhelmingly popular. I don't know that there are many things that 94% of Americans agree on, but this is one of them. And so we really should recognize the popularity among people. The other thing is that there are over 800 sections of the United States Federal Law Code that make reference to sex-based differences. So what am I saying? I'm saying that the Constitution does not include women, that it never was created originally with the understanding that men and women have are legally equal in standing. And the federal law code includes over 800 references to laws that make a distinction based on someone's gender. And let me give you an example of this. For example, in some states, it will have a law regulating barbers, people who cut men's hair, that barbers are men and barbers are allowed to cut men's hair and women's hair. But hairdressers are women. and hairdressers are only legally able to, are only legally allowed with their license to cut women's hair. So that legal distinction based on gender privileges barbers over hairdressers, right? So there are so many places in the federal code and in state law that allows discrimination. That discrimination is legal in the United States because of these hundreds of state and federal laws. And the other issue that's interesting is I told you that the United States Constitution is the oldest in the world. Every constitution that has been written since 1950 in the world includes this simple principle that men and women have the same legal standing. So the United States doesn't have it, but every world constitution since 1950 does include it. And in fact, the 14th Amendment, which is one of the amendments that was ratified after the Civil War. So I know all of you from your American history classes and your political science classes know that after the Civil War, 3 new amendments were ratified for the Constitution. And I told you there's only 27 in total, so 3 at once. This was pretty big, right? So after the Civil War, there were 3 amendments ratified. The 13th Amendment to end slavery, the 14th Amendment, which defines citizenship, equal protection, and due process, and the 15th Amendment, which granted the right to vote to African-American men. The 14th Amendment is particularly interesting in this case because in the 14th Amendment, it describes specifically male citizens 3 different times in the 14th Amendment. So specifically excluding women. And this was very troubling to the women who were fighting for women's rights, because not only were women not being recognized in the Constitution for the right to vote, but they were being specifically left out of the Constitution by saying male, by inserting the word male in the Constitution. So the women in the women's rights movement who fought for the right to vote were successful in 1920 in getting the 19th Amendment. The 19th Amendment is just 100 years old, and the 19th Amendment was ratified in 1920 and granted women the right to vote in the United States. So this was a major step forward after 140 years of American history that women have never been included in the Constitution. The 19th Amendment is the one and only place in the American Constitution that uses the word woman. That's the only place. And the women in the women's suffrage movement understood and actually believed that the suffrage amendment was just the first step for women to get opportunities in politics and economics, that this was only the first step for women's political and economic equality, that the vote wasn't the end game. This was just the first step in gaining women's equality in the United States. Also, we saw after 1920 that Congress did pass 3 legislative acts that help fight discrimination based on gender. One was the Equal Pay Act of 1963. In 1963, the Congress passed the Equal Pay Act, which made it illegal to pay people differently. In 1964, Title VII of the Civil Rights Act said it was illegal to discriminate, and this created the EEOC and made it, gave a legal basis for lawsuits in discrimination on hiring and employment. And then Title IX, which was passed by Congress in 1972, which required equality in education programs and sports programs for any college or university that received federal funding. So many of you have heard of Title IX. I mean, Title IX is actually even the name of a women's sports clothing brand now, because it represented an important change in the way women were accepted in colleges, graduate programs, law schools, medical schools, and also in college sports. So if you're a college that wanted to be able to get federal funding, you had to provide equal opportunities for female students. And this finally removed the quotas in law schools and in medical schools. So there was some progress, that the 19th Amendment gave women the right to vote, that the Equal Pay Act, the Civil Rights Act, and Title IX also attacked and sought to reform discrimination in education and hiring and in pay. However, that basic principle was still missing. The basic simple principle that our society and our legal code views women and men equal in the eyes of the law was still missing. And so Supreme Court Justice Ruth Bader Ginsburg, who was in the 1960s and 70s a law professor at Rutgers and then a lawyer for the ACLU, began arguing court cases to challenge federal laws that treated men and women differently. But I said before that there are like 800 federal law codes that treat men and women differently. If you had to file lawsuits to test all 800 of those laws in order to change them, it would take hundreds of years. That it was a very cumbersome process. And so Ruth Bader Ginsburg and Pauli Murray, also a very important legal mind, developed the legal arguments to reform the discriminatory nature of the United States law codes. So for example, there was the case in the 1960s of Hoyt versus Florida, which in Hoyt versus Florida, a woman was tried in a criminal case, but only men were on her jury. And she argued that that was discriminatory to her as a defendant because she was not judged by a jury of her peers, right? So that we see lawyers like Ruth Bader Ginsburg begin to use test cases to reform the law codes and to develop the legal arguments to reform women's inferior legal status in the eyes of the law. I want to talk a second also about the writer of who wrote this amendment. I read you the simple amendment earlier. Who wrote it? Well, a suffragist and women's rights advocate named Alice Paul. And I like to share her with you because she is a New Jersey woman. She grew up in South Jersey. She was a Quaker. She grew up in a Quaker family in Moorestown, New Jersey. Her house is still there. It's a historic national landmark, and you can go visit her house in South Jersey. It's outside of Camden. And she was one of the women's rights advocates who understood that suffrage was only one step in the journey of gaining full legal equality. And so she's the one who wrote the Equal Rights Amendment in 1923 and really spent the rest of her life advocating and fighting for it. She understood that the law was instrumental in gaining women's rights, that changing the law was going to be important to fighting for women's rights. And so she went to law school in the 1920s, and she actually earned 3 different law degrees in the 1920s because she understood that the future of women's rights was in legal change and reform. And she is really one of the great personalities that probably people don't know enough about in her vision, her understanding of how to make change, and the simplicity of writing that amendment in the 1920s. So how do we change the Constitution? How do you get one of those to be one of those 27 rare amendments? The amendment has to be written, and you have to have a sponsor in the Congress. Somebody has to introduce it from committee to the floor of the House and then of the Senate. It has to be voted on and debated. The Equal Rights Amendment was locked up in congressional committees for decades. Nobody would bring it to the floor for a vote or even for a debate. And so from 1923 until 1972, almost 50 years, the ERA was locked up in congressional committee. But finally, in 1972, after about almost 50 years, Congress considered it. Somebody brought it to the floor of the House, and it was debated and passed in 1972. It was brought to the floor of the Senate and passed the Senate in 1973. And so why in the 70s, right? So why in the 70s, after 50 years, does the ERA finally get some movement? Well, I would argue that the height of the women's movement, that the time in America was ripe for this kind of change, that the women's rights movement and the civil rights movement had created a spirit of social change and a positive view of equality in society. So the political atmosphere and the political will was there to finally consider this amendment after 50 years of it being just dead in congressional committee. It was passed by the House and the Senate, but after being passed by the House and the Senate, it needed ratification by 3/4 of the states. That's how it becomes an amendment. It's not enough that the House and the Senate pass it, then it has to go to the states for ratification. And when the Congress passed the ERA in 1972 and 73, they did something unusual. They attached a deadline, which had never really been done before. They said, we will pass this, but you only get 7 years to convince the states to ratify it. And so ERA advocates and supporters took the amendment to each state and had to do so, had to have it ratified by 1979. And they do not by 1979 and got an extension until 1982. In that time, the ERA received 35 states' ratification. They fell short by 3 states. So in 1982, the ERA was defeated 3 states short of the 38 needed to become a permanent part of the Constitution. So in this map, you can see where the states are that failed to ratify it in 1982. The green states are the ones that approved of the ERA. New Jersey does approve it. The states that do not approve it are in the West, Nevada, Utah, and Arizona, and in the South, Florida, and the southern states, including Illinois and Missouri here, right? So these are the states that defeated. What is the reason for the failure of those states? What is the reason that they did not ratify it? Well, it's largely due to the efforts of a Stop ERA campaign led by this woman with the bullhorn, Phyllis Schlafly. Phyllis Schlafly had been a lifelong Republican and conservative who had a master's degree from Harvard in political science. So she was a very highly educated, middle-class woman from Illinois who had run for Congress a couple of times. She had political ambitions herself, but she had never been elected. She had spent her career as a political operative and as a very strong voice in Republican politics. This became the issue that Phyllis Schlafly was able to really build a political fame for herself. And while she had been largely marginalized by her party in terms of giving her leadership, when she became the leader of this grassroots movement to stop the ERA, she became nationally known. And so maybe some of you have seen the Hulu series called Mrs. America, but Mrs. America was on Hulu last spring and highlighted the biography of Phyllis Schlafly. I believe Cate Blanchett plays her in the Hulu series. So maybe if you are interested in learning more about her, Hulu kind of has brought her back, showing her life and her role in Republican politics. And her campaign was largely generated around her views against feminism. So the feminist movement had become very much a part of American culture in the 1960s and 70s. And Phyllis Schlafly famously called feminism a disease, that feminism taught women to be victims, that feminism was wrong and wrong-headed, and that women were very lucky in America and that they shouldn't complain. And so she became the face of the anti-feminist movement in the United States in the 1970s. She built a grassroots movement to fight against the ERA, and she was very successful. She also engages in what we would call today culture wars, that she peddles theories of fear, that if the ERA is passed, then gay people will have rights, that gay people will be teaching their children in the schools. And she really used homophobia as part of her argument to fight against the ERA. And so she really is one of the first people at the height of the women's movement to have success in attacking feminism and the women's rights movement. And she really, I think, should get credit, and I don't think Republicans give her enough credit for bringing about a resurgence of American conservatism. She really gives birth to a new conservative movement, and she shows conservatives how to win against liberals. And so I think that with her campaign, she argued against the ERA by arguing 4 main points. She said that we should not pass the ERA because if the ERA becomes part of the Constitution, women would lose some of the legal protections that they have as workers. So some of the laws that treat men and women differently were written to protect women workers. So women should not have to work late at night. Women should not have to have jobs where they are required to do heavy physical work, things like that. And so Phyllis Schlafly argued that there would be some losses if you wipe away all the laws that treat men and women differently. There would be some losses and women would lose protections. Now, on the women's rights side, women said, we think that everybody should be protected. Men should have protection in the workplace too, and you shouldn't distinguish between male and female workers. However, this was one of the arguments that Phyllis Schlafly made to fight against the passage and ratification of the ERA. She also argued that in the case of divorce, women would lose alimony and child support that women in the 1960s and 70s generally received once they got divorced, because it assumed that women stayed home with children and men went out to work. And she said, if you get the ERA, you're not going to be guaranteed alimony and child support anymore. She also argued that women would be forced into the military draft, that up into the 1970s, the selective service was a part of American life, that men went into the military and had mandatory military service, and women did not. And she said, well, women would be forced into the military. Women's rights advocates said, well, maybe women want to go in the military. You know, they may want access to military careers. And the last one is the potty problem. Everybody it always kind of gets reduced down to the bathroom, I always say. So she also argued that if we had the ERA, it would mean the end of having men's rooms and women's bathrooms, that there would be unisex bathrooms, and wouldn't that be horrible? So these were the four arguments that Phyllis Schlafly used, and also she educated everyone in her movement on how to make these arguments, make them quickly and clearly, and she was very successful in training the members of the Stop ERA campaign. So it might strike some of you as ironic that while some women were fighting for the ERA, other women were fighting against it, that it's women versus women here. But this is very common in women's history. We saw the same thing in the suffrage movement. There were a lot of women who fought against suffrage as well as fought for it. So this is not unusual. In women's history, there's always factions and factions of women who don't agree with each other. So women are not a homogenous or unified group by any stretch of the imagination. The arguments in favor of the ratification of the ERA are also important. So women who were in the pro-ERA camp, who wanted the ERA, argued that the ERA should would protect everyone. So if you wanted laws that would protect workers, they would protect all workers, men, women, and women as well as women workers. So the ERA would just make protections for everyone, that nobody would be deprived of their rights, and that the ERA would force discriminatory laws into the scrap heap of history. And it would also cause the revision of those 800 federal laws and hundreds of state laws too, that it would force the federal and state laws to be reformed without having to bring a test case against each and every single one of them. So the idea that the only other way to reform the federal code and the state law code was to bring a case, every single law had to be challenged one by one. So the ERA was a much cleaner, simple reform for the problem of not having women in the Constitution and having discriminatory laws in the US law code going all the way back to the English common law. So Ruth Bader Ginsburg wrote and argued as a lawyer that the Equal Rights Amendment would dedicate the nation to a new view of rights and responsibilities of men and women. That she believed that having different standards of law for men and for women was what she called constitutionally intolerable. That at this point in history, having laws that treated people differently was not constitutionally tolerable, and that men and women should be treated equally in the eyes of the law. And so her career as a lawyer, as a law school professor, and as a Supreme Court justice, this really was one of her major principles as a jurist. So what changed things? So in 1982, I said that the ERA expired, 3 states short. It was dead. 1982, nobody has talked about the ERA since 1982. That's a long time ago, right? It's getting to be a long time since 1982. So what changed? What brought it back? What brought it back into our conversation? Well, I think that what brought the ERA back into the conversation was the election of Donald John Trump. When President Trump was elected in the 2016 election and took office in January of 2017, we saw women react. And I have a picture on my slide here of the Women's March in January of 2017, and women were very unnerved by Trump's election. And his statements during the campaign and his promises to change judicial appointments and things like that really were unnerving to women, and they began to worry that they were going to lose important legal and judicial victories of the past, that things were going to be rolled back, particularly in terms of reproductive freedom. So after 2016's presidential election, there was a resurgence of women's activism. And the resurgence of women's activism didn't just take place in marches like the Women's March, but it inspired thousands of women to run for local and state office. And so by the 2018 midterm elections, women had begun to serve and be elected to state, local, and national office in the biggest increase in American history. So in 2018, the midterm elections were called a blue wave election that swept thousands of women into political office for the first time. And on this slide, I actually have a picture of Danica Roem, who was elected to the Virginia state legislature, and she's getting a tattoo in this picture. And her tattoo is the text of Section 1 of the Equal Rights Amendment. So she's getting actually the text of the first section of the Equal Rights Amendment tattooed into the arm. So what does this tell us? This tells us that the election of President Trump in 2016 made women worried that Title IX was going to be weakened. And certainly Betsy DeVos was the cabinet member in the Department of Education, was and did try to weaken Title IX, which I told you before, which was one of the important congressional victories, right? So Title IX was affected. The appointment of conservative judges to the federal bench was also an objective of the Trump administration. And these conservative judges received lifetime appointments. So conservatives appointed for life all over the country to federal benches meant that any case was going to, on discrimination, on the environment, on reproduction, all different issues that women were concerned about, was going to be judged by a conservative. And so women in state houses, in Congress, in local office were interested in bringing the ERA back. So what happens is, especially on the state level, is that women were replacing people in their state legislatures who were not interested in the ERA, and they were. So they bring the conversation back to their state legislatures. And I really think that the ERA came back after 2016's presidential election, largely because women were afraid. They were afraid if they didn't have it, that they were going to lose the gains that had been made already. Not just to advance women's rights like in the 70s, but to not lose what they had gained in the past. They feared these conservative judges. They feared the conservative policies of the Trump administration and the action that they were taking against things like Title IX. And so we see that women really woke up after the 2016 presidential election and run for office to, and one of the things that they were interested in was the bringing back the ERA into the conversation. So what happened in 2018, this is just a little graph here that shows the 2018 blue wave election. So we see this is women serving in the House of Representatives by party. So here's the blue wave, right? These women who ran for office and were elected in the 2018 blue wave election. We really see this enormous increase. Now, women are still not 50% of the Congress, right? Women are only 25% of the Senate, 24% of the House of Representatives. So still not equal 50-50, but this influx of women into politics had really changed the conversation. So the ERA was defeated in 1982, largely due to the success of the grassroots movement, Stop ERA, led by Phyllis Schlafly. It was dead in 1982. So they needed 3 more states. So how are they going to get the 3 states that they need? There was a 3-state strategy that was put out by the National Organization for Women, which is a pressure group, a political pressure group, lobbying group. And in 2017, Nevada had a conversation about the ERA in their state legislature, and they ratified it in 2017. Then Illinois in 2018. And then in 2020, January of 2020, just last year, Virginia ratified the ERA. So now we're kind of coming back to our constitutional questions. So the ERA has been reconsidered. It now has 38 states. But now what? It had a deadline, and the deadline had passed. So what does this mean? Will it become part of the Constitution? So the last three states, as I mentioned, passed the ERA: Nevada, Illinois, and in Virginia. So we have our 35 plus 3 equals 38 states. It has the 3/4. Now what? Now what's going to happen? And so this is really the conclusion here of my talk. So they faces obstacles, right? The deadline had passed. However, in 1992, the 27th Amendment passed and was ratified after, are you ready? 203 years after it was first proposed. So the 27th Amendment was proposed by Madison 203 years earlier. And the amendment essentially is about congressional salaries. Can Congress vote for their own raises? And it's in 1992 that Congress finally passes and it becomes ratified and becomes the 27th Amendment of the Constitution. So why am I telling you this? I'm telling you this because if an amendment can be considered and ratified after 203 years, then maybe this one can be after a mere 40 years, right? It really takes the idea of the deadline and says maybe deadlines aren't so important. Another obstacle is that 5 states now want to reconsider their ratification after the fact. And they say, well, we want to take back our ratification of the amendment. No backsies. Once you ratify it, you can't unratify it. And there's legal precedent for this. After the Reconstruction amendments that I mentioned earlier, New Jersey and Ohio tried to unratify the 15th Amendment, and they were not allowed to do so. So no backsies. Once you ratify it, you can't take it back. So what happens when you have your number of states, 38 states have ratified it? You send it to the archivist of the National Archives. The archivist of the National Archives is a man named David Ferriero, and he is the one who keeps the Constitution and has to do really just the bureaucratic administrative function. He certifies the new amendment. So 38 ratifying states for the ERA, they send it to David. Mr. Ferriero, here's our 38 ratified states for the ERA. And he is the one who is supposed to just do the administrative function, certify that it's part of the Constitution. But the Trump Justice Department said no, that the Department of Justice under the Trump administration did not recommend that he do so. And they said that the ERA had run out of time and that they had to start all over again, all the way back to congressional approval and state ratification. So he's getting sued. The 3 states, Nevada, Illinois, and Virginia, are now suing him for his failure to certify the Equal Rights Amendment. But it sort of fell on him. The other option for getting the ERA to be certified as part of the Constitution lies in either a Supreme Court challenge, and so the Supreme Court may decide that the deadline can be disregarded, or Congress. So I come back to my earlier point about Article 5, that Article 5 gives Congress the power. And so the House and the Senate both have resolutions to accept the ERA and to disregard the deadline, which was unusual, and that deadlines had been never been used in any other amendment. So it's going to be up to congressional approval or the Supreme Court to make the final decision whether the ERA becomes the 28th Amendment or not. So last spring, in June of 2020, Lisa Murkowski, who is senator from Alaska, she's a Republican, made a speech on the floor of the Senate where she was speaking really about the 100th anniversary of the suffrage, but she also spoke very passionately in favor of the Equal Rights Amendment. And she has co-sponsored a Senate resolution to nullify the deadline and to approve the ERA. And she said in her speech that you cannot put a time limit on equality and that it's long time, that women have waited long enough, and that women's equality is fundamental to the American way of life, and that it's time that it be approved. So my thoughts are that I have been following this story for many years and teaching it in my classes for many years. I believe that this is going to happen. And I believe that the ERA will be, by one way or another, whether it be through congressional action or through Supreme Court decision, I believe that it will become part of the Constitution. So that's my opinion at the end here. But it is needed. It is part of a long history of the way women have been viewed differently from men in the eyes of the law and in the Constitution. So does anybody have any questions that they'd like to ask about the Equal Rights Amendment?
Yeah, I had one. The third section of the amendment said that it would only take effect 2 years after ratification. Why was that added?
That's a great question. I think that they have a period of time added there. And, I'm not entirely sure. I have to think that perhaps it was time for the states to adjust to this, to adjust their law codes, the state codes, and to give time for the legal system to adjust. And I was sort of, what comes to mind when you ask that very good question is like marijuana laws, right? Now we have all these laws on the books criminalizing marijuana. And so if like tomorrow you're like, poof, no more marijuana convictions, like what happens, right? You have to kind of have a period of time, I think, for the laws and the policies to kind of be readjusted. And I think that's partly why they would have that. Jonathan, do you have any sense of why there might be a 2-year waiting period?
I completely agree with your assessment. And to change the laws, some of the laws of the federal code, the laws at the state level, although I think 2 years is pretty generous, maybe 1 year would be okay. But yeah, that's I think the rationale for it.
Yeah, thank you, Jonathan. I definitely think that's a great question. Yeah, Frank.
So I'm just asking a question regarding is there any other laws that they might put in with the ERA, or will they branch out off of it? Or do they have any branch out off of it, or is it just this one thing, one-time deal, just this?
Well, okay, so the ERA would be added to the Constitution, right? So we said the Constitution is really just the general principles. And so it would lay out clearly the simple principle that men and women are viewed equally in America. The federal code and the state law code follows that, right? And has to conform and obey that. So once it's part of the Constitution as a simple principle, then the state laws and the federal laws would have to be reformed to follow the Constitution. So that's why I like to explain at the beginning what the Constitution is versus what the federal and state law code is. They are separate. The Constitution guides it.
Jane, we have a question in the chat from Michael. He wants to know what were the 5 states that were wanting to reconsider their ratification?
Oh, that's a great question. 5 states, and I can't remember. I think it was like South Dakota. I would have to look that up quickly to see the 5 that wanted to take it back, that wanted to withdraw their approval. But that would be pretty easy to Google and find that out. But I think that it's a non-starter, which is why I guess I really didn't dig into that too much, because it's been tried before and you can't. It's just not allowed. The other thing that I think is really interesting is that James Madison wrote, the founding father, he wrote that once something becomes an amendment to the Constitution, it's in there forever. It can't be taken out. Unless you pass another amendment to repeal it, it's forever. It's in toto, it's forever, and it's clearly, part of the law. Ave, go ahead.
Yeah, thank you. I was just thinking about the position of the executive office with President Biden, and I was wondering what your thoughts are about, is he going to be able to push through this as much as President Trump influenced it? Because it seems like he's really working towards equality with his appointments, and just wanted to hear your opinion on that.
Yeah, I think that this is definitely an important change in supporting the ERA. I think that certainly if he was going to ask the new Justice Department what they thought, that would be an interesting question. Would the Justice Department today change their opinion on its approval by the archivist, right? It's so funny that this comes down to the librarian, doesn't it? The person who's the librarian in the National Archives gets to kind of have the final say here. But the fact that we do have a new Attorney General and new appointments in the Department of Justice, I'm sure that would be could be a very interesting turn of events. I also think that the support of the Biden administration for equal rights would be pretty much a slam dunk to assume as well. And the fact that there is a strong support by the Republican women, Susan Collins and Lisa Murkowski both are sponsoring the Senate resolution to nullify the deadline. So the fact that you have 2 Republican women in the leadership here to make this happen is also, I think, in its favor. So it seems to be something, as I said, 94% of the country approves it already. It's a popular idea. And so right now, I really feel that most of the opposition is bureaucratic. It's a bureaucratic process of how do you make this happen and still follow the bureaucracy and the procedures for approving amendments to the Constitution. It is hard. That's why we only have 27 of them, right? It's not an easy, fast process. It's cumbersome, and it's cumbersome on purpose, right? Because you don't want to be amending the Constitution every year. You don't want to be too flip about changing the Constitution all the time. You want it to be a thoughtful process. So I think, Ave, I do think that the spirit of the administration and even the support of the women Republicans in the Senate also favor this. So I am very hopeful.
What happens if it's approved and the states fight it? what happens if the government of the state, the governors or whoever the politicians of the state, it's now approved and they don't want it? How can they fight? Would they fight it, or are they forced to do this?
They will be forced to obey it. It will be part of the Constitution. It will be an official amendment forever, and you can't undo it. It is like, it would be like slavery. It would be like saying, well, we want to still have slaves. Too bad. Have slaves. It's slavery was abolished by the Constitution. You can't do it. Even if you want it, you can't. So it would not be, they would not be able to avoid following it.
But they have all kinds of little laws and things that they propose to get around, that there's all the loopholes that they find to stop this.
What kind of loopholes did you have in mind?
Well, for example, with the voting, how they are now making it very difficult for certain groups to vote because they've changed the voting places, and just to make it harder for those who they feel are against them, that oppose them, that they don't want these people to be available to vote. So,
well, the democratic process. So for example, if the ERA was part of the Constitution, but a state still wanted to discriminate against one gender, men or women, for one reason or another, they would have to be challenged in court, and the constitutional argument would be clear. Right now, it's not clear, right?
I know that.
So-
That's
so
it.
with-
It's not clear now. Yes.
So with the clarity of the ERA, they would lose, right? That the Constitution takes precedence because it is the principles of the entire government. And so because the Constitution is the ruling principle, judges have to follow the Constitution and make their decisions and their rulings based on constitutional principles. And they would not be allowed to violate them.
I hope so. I just don't trust anybody today. That's all.
Well,
It's
that's why
just-
we have the Constitution, right? That's why we have laws, because you can use the courts and you can use the institutions of our government to object to violations of those principles, right?
And then it takes time for court. It can go on for a long time before it's resolved by the courts.
It can. It takes time. It certainly women have waited hundreds of years for this.
Yeah.
So women have also waited a really long time. So it is an arduous process, but there are mechanisms, right, for fighting against injustice or violations of the laws and the principles.
Well, I have to thank you. I really enjoyed your talk, and it reinforced things that I was feeling positive about. And you explained many things to me that I didn't quite understand. And I want to thank
You're
you.
very welcome. It's my pleasure. All right, I think Frank had another question.
Could Biden somehow do an executive order for this, or no?
Nope. Remember I said, who has the authority? Congress has Article 5 authority. And Congress also has authority over the judicial and the executive branches. So it's going to be Congress's job. And, if we follow the way that the Constitution is the charter for the government. And so it's going to be in the authority of the Congress to make the decision, or the Supreme Court to rule. Go ahead, Maria.
Yeah, well, thank you so much for your presentation. It's always so good to come back and hear you speak on these issues, especially because I remember in class you were so excited about these last days ratifying the ERA. But my question is, in your opinion, what do you believe would be the most straightforward path to ratify the ERA? Would it be through Congress, or would it be through like precedent in the Supreme Court? And how likely is it to pass either way?
That's a great question. And it's so nice to hear your voice, Maria. I loved having you as a student and I miss you. And I'm so glad that you were able to come today. I think the most straightforward path would be congressional action. And since the House resolution has already passed, the Senate resolution has not passed, but it has been sponsored by Lisa Murkowski and Ben Cardin of Maryland. They are co-sponsors of the Senate resolution. So the Senate could really debate and pass this, and it would be done. So I actually think in my opinion, the most politically straightforward process would be congressional approval, and congressional action that would disregard the deadline and therefore make the ratification credible and would integrate it into the Constitution formally. Jonathan, do you have any thoughts on that?
No, I wholeheartedly agree, Jane. The congressional action will be the way to resolve this, and they can essentially pass this legislation regardless of the time frame that they imposed, and which was, arbitrary and ridiculous. And so I think I agree with you, and I share your optimism, and I love your optimism that it's going to come to be, and it really seems like there is the momentum there to get the House and the Senate, which the House, of course, as you mentioned, already has passed it, to get the Senate on board and for them to pass it.
Yeah, great. I agree. And I also think that the fact that the Congress passed the 27th Amendment after 203 years, they set precedent for themselves to consider an amendment that was over 200 years old, that they seem to, that would be kind of hypocritical, I think, for them to pass that one and not pass this one, or at least not consider this one. Especially, it seems to me like a real slam dunk bipartisan kind of movement at this point, since it's so overwhelmingly popular in the country. So I'm just looking at the chat and trying to see if there are any questions here. Some people are typing them in. South Dakota, Nebraska, Tennessee, Ohio, and Kentucky were the ones that tried to remove their ratification. Good. So thank you, Diana, for answering that question. And it's really an exciting time. It's an exciting time to be living through all these incredible changes in our country. And it's really been a great time to become aware of how our government works. And I'm sure that Professor Moshberger really emphasizes the connections between the functioning of government and all the things that are happening now that are really getting us to remember what an impeachment is and what things, how all these things work. And we live in an amazing country where we can freely talk about things and be part of the process of politics. And so we're so lucky, really, to be able to debate these things and to consider them and to talk about the history of both women's history, legal history, and political science all kind of married together, which really makes it a fun conversation.
Absolutely. It's a wonderful synthesis of everything coming together as a whole. We're completing the pieces of the puzzle that need to be there to make us whole, to make us truly equal. in every sense of the word where we really need to be. And it's high time for these changes to actually come to bear. Are there any more questions? Anybody want to raise their hand or unmute and ask a question for Professor Scimeca before we wrap up?
I just want to say that was a good presentation, and it opened my eyes a little more to the women's, movement and everything, and how they're developing more and more over time, and finally, becoming equal with us.
All right. Thank you, Christian. Thank you for coming.
My pleasure.
Anybody else? I feel like there might be some that want to ask a question, but are hesitating. Anybody else have a question before we get to our closing?
If anybody wants a good book on Alice Paul, I'll just recommend a couple. If you're interested in learning more about her and her work in women's rights and in peace, a lot of these women who were involved in women's rights were also involved in the peace movement, international peace. And there's a great book on Alice Paul called The Woman's Crusade. And I'll type it in the chat. And it's written by a local journalist and writer named Mary Walton. And so I would recommend that book if you're interested in a book on Alice Paul. I also would recommend, if anybody wants a book on the legal arguments about the ERA, in her own words by Ruth Bader Ginsburg, is really a very clear, easy to read book if you like law and like to understand the legal arguments, constitutional arguments in the different Supreme Court cases. I was really considering including more discussion of things like Frontiero versus Richardson and Meritor Savings Bank and the VMI case. I mean, there's so many gender discrimination cases that were important in bringing some of these issues to light and the arguments to light. So I think that, if you're interested in law, it's really fascinating to see how these arguments developed. And certainly if you want to learn more about Phyllis Schlafly, I have a great book on her. I don't have a book that I recommend on her specifically, but I'm reading this great book on Republican women, which is a great book on Republican women by Catherine Rimpf, who is, this book is great for the history of Republican women and their impact on the conservative movement, which I'm very interested in as a scholar. And I think that if you're interested in political science, if you're interested in conservatism, which I really am, I recommend this book to look at the women in the conservative movement. Some of the things that I've been working on include the impact of women in Republican politics, and that after women got the right to vote, most women in New Jersey joined the Republican Party, that the Republican Party really welcomed women as members. And I think 4 out of 5 women in New Jersey joined the Republican Party in the 1920s, that they had by far more female members than the Democratic Party. So it's really important to recognize the important role that women play in the different in the different parties, and how the arguments over time change. And that this conservatism that we're used to now didn't always exist, but it's really kind of only in the last 40 to 50 years. Would you agree, Jonathan?
Yeah, I agree. I totally agree. Jane, I saw two more questions from both from Amanda in the chat. She asked, can the ERA shift power from state to the federal government, from state to the federal government? And she wants to know if you've ever visited Alice Paul's home in New Jersey.
First of all, yes, I have visited Alice Paul's house in South Jersey, and there's kind of an interesting story attached to it. So she lived in this nice kind of farmhouse in South Jersey, and it's really very much the way it was when she lived there. It's farm, it's beautiful. And then when you go inside, you can see there's an exhibit. The Alice Paul Institute has maintained a beautiful exhibit there of memorabilia, things from her life, banners, and all stuff from the women's suffrage campaign. And then they have a film. So when I went, I took my husband and my son, and I got my husband to come because his favorite chicken wings restaurant is nearby. So he agreed to go to the Alice Paul house because I promised him chicken wings afterward. Okay. So my son at the time was about 6 years old, and we were going to take him to the aquarium at Camden's aquarium as part of the day. So we went in to see the exhibit. They have a film, and the film showed when she was fighting for the right to vote, she would go on hunger strike as a prisoner, a political prisoner. She said, I want to be considered a political prisoner. And she went on hunger strike. And they showed in the film the way that they would force feed her in prison. And it was pretty gruesome. My son was so upset by the film that he was crying and he was horrified and traumatized, and we had to go home. So I got to fulfill my dream of seeing Alice Paul's house, but I've permanently scarred my son. And but we did get chicken wings. Will it change the balance of the states and the federal government? I don't think so. I really don't. I don't think that, I actually don't think it would have that big of an impact in terms of state power or states' rights. I think it would merely provide the correct guidance to fulfill the principle of equal rights. So I don't think that states would lose a lot of their autonomy as a result. Would you agree, Jonathan, or can you see any scenario where that might shift or diminish states' autonomy?
I don't think so. I see this as being empowering, and I think it'll shift it, of course, in terms of full equality where we need it to be. And of course, national law is predominant, so they'd have to adhere to it. I think it'll be ultimately. I think it'll be fine in the end.
Yeah, I'm trying to think of an example of how a state would be negatively impacted or feel infringed, their power was infringed upon by the ERA. I can't think of an example. It could be. I mean, I think whenever there is a major change, I think that there always is, there is a ripple effect that you do have to consider, but I can't envision anything particularly negative coming from on the state side of things in terms of their authority or their autonomy. You just can't discriminate against women anymore. I think that Maria had one more question in the chat about what you can do, if there's anything that we can do to push the ERA to be ratified. Certainly it's really come down to the Senate's hands. to get that, you know, I don't know, is it Mitch McConnell again that has to be convinced to bring the resolution to the floor? That may be an obstacle that, you know, perhaps people could write to him or to, you know, to convince him to bring Senator Murkowski's Senate resolution, I think it's Senate Resolution 6, to the floor for consideration and debate. I think that might be something that could be done from the constituency standpoint. Did you have any opinion on that, Jonathan?
No, I agree. I wholeheartedly agree with advocacy. So writing letters, making some phone calls, if you want to start a petition or sign on to a petition that's probably already been crafted. So certainly do that outreach, do some stuff on social media, whatever you can do to generate some more buzz to push it over the home stretch, push it down the home stretch across the finish line.
Yeah, and we should support Senator Murkowski in her bid for re-election in Alaska. I think, you know, I'm sure she's going to have a tough election up there.
Right. Once again, she's being primaried. You know, she's facing a challenge, you know, from the right, somebody who's more conservative than her. It's happened before, and she did lose in the primary, but she won re-election through a write-in campaign, which was just crazy.
It's
that
so
one
amazing.
boggled my mom. Yeah, that boggled my mind. You know, that she was able to win a U.S. Senate election through a write-in campaign. That's crazy. You know,
it is, and it's a shame that she's, you know, I guess, you know, whatever, you know, she's going to face pushback, but she's really brought a lot of attention to her state, and she certainly says the right things in terms of she is an advocate for her people that she represents. And so, you know, she's unbossed. She doesn't want to be bossed. I don't blame her. And I think I will, in my appreciation for what she has done for the ERA, I think I will certainly support her and maybe even send her a contribution.
Very interesting. Yeah. And you unbossed, that reminds me of Shirley Chisholm and unbought and unbossed.
Yeah, that's it. Unbought and unbossed.
We need more
Next
of that.
time I come, I'm going to have to tell you my Shirley Chisholm story. I actually met Shirley Chisholm when I was a freshman in college. She was teaching at Mount Holyoke College, and I got a chance to share a taxi with her.
Yeah.
And I got to meet her. So it's like one of my favorite stories of brush with fame. It's that I got to meet Shirley Chisholm in 1984.
Wow, it's amazing. Really cool. Really cool.
Yeah.
I want to wrap up now. I noticed the time is getting away from us here, but that's because it was such an amazing presentation. So I just want to say, wow, you know, thank you so much. You guys, everybody, you can see why Professor Scimeca is an inspiration to me. And I know she's an inspiration to so many others as well. So if you haven't already done so, you really need to take her women's history course because history, it's a history that's been neglected and needs to be learned and needs to be shared. I think it needs to be embedded into the core curriculum. And I want to ask everybody to unmute, do something that we haven't done, and that we really don't get to do via Zoom. You know, because if we were in person, there'd be a beautiful thunderous round of applause for Professor And so everybody, can you please unmute now and join me in 1 minute here. I'm waiting for everybody to unmute, right? And so let us show our thanks and appreciation for her time and all of her effort and her energies into bringing these issues to light and making a difference for all of our students. And I truly appreciate you, Jane, for everything. Everybody, a big thunderous round of applause for Professor Scimeca.
Thank you.
Thanks so much.
Thank you.
Thank you.
Oh, thank you, everybody. Thanks so much for coming out today. We really appreciate it. Really appreciate it. And again, sign up for Women's History if you're going to be here in the fall. If you haven't taken it, it's going to be a wonderful experience.
Have a nice day. Thank you.
Thank you. Thank you guys for coming. It was my pleasure.
Have a nice
Thank you
one.
so much.
Bye.
It was
Bye.
good.
So nice to see you all. Bye, Maria.
It was good seeing
Bye.
you
Nice
again,
to
Mrs.
see you.
Scimeca.
Bye. Miss you guys.
I'm happy. I'm still one of your students.
Oh, yay.
Have a good day.
You too, Ashley. See you.
See
See
you Thursday.
you Thursday.